Hey everyone, and welcome to today's webinar hosted by Ciphr with our friends at Shoosmiths. It's the October 25 Employment Law Update. It's great to have so many of you with us live today. I'm thrilled to be joined once again by the team from Shoosmiths. So you might already know Stuart Lawrenson, who's partner and head of Southampton office. Welcome, Stuart. Hello, and joined also by Sian Hall, who's a legal director at Shoosmiths. Welcome, Sian.
Thank you.
And also by Antonia Blackwell, who's our Q&A powerhouse. She's going to be helping us tackle your questions during the broadcast. And we have with us Sarah Kerr, who's one of our account development managers here at Ciphr. Welcome, Sarah.
Thank you.
Quick look at today's agenda. Sarah's going to give you a little introduction to Ciphr, just in case you haven't come across us before. And then we're going to hand over to Stuart for the case law update. And Sian's going to take us through what's on the horizon. And that's really going to be a deep focus into the Employment Rights Bill, which I know is occupying a lot of us right now, trying to figure out what's coming, when it's coming, and what on earth we need to do to adjust for it. So this webinar is being recorded. We'll email that recording to you later today. So if you miss anything or you want to share it with a colleague, look out for that in your inbox. Please use the chat to share any comments or thoughts, and there's also a dedicated Q&A area to send in your questions to the Smiths team. And with that, I'm going to hand over to Sarah. Thanks, Sarah.
Thank you. Hello, everyone. Welcome. So I'm just going to start by giving you a bit of an introduction to Ciphr. So we were founded in 1993 and have since grown into a UK-based provider with over 230 experts that are dedicated to helping mid-sized organisations achieve more through better people management. We proudly support over 1,000 organisations with over 2 million users relying on us, relying on our solutions. Each year, our payroll bureau processes over 2 million in payments alone. Our cloud-based software is built with security and scalability at its core, ISO 27001 accredited, Cyber Essentials Plus accredited, hosted on Microsoft Azure, and approved for use through the G-Cloud framework. Next slide, Catherine. So our mission is to amplify HR. So we know that when HR has the right tools, visibility and senior sponsorship, it has the power to transform not just processes, but people's lives, careers and workplace cultures. It helps people thrive, reduces turnover and creates the foundation for long-lasting success. At Ciphr, we're here to amplify HR's impact, to elevate its voice in the boardroom and to empower managers to shape future leaders and to make more meaningful change happen, giving HR the recognition that it truly deserves. Next slide, please, Catherine. And we're not just about tech either. We are a true software solutions partner, are here to help businesses grow, develop and reach their full potential. Our tools bring together intelligent people data that really helps to inform and shape strategic decisions. And behind that technology is our people. So our people deliver the perfect blend of services, processes and support, ensuring that every organisation that we work with can have meaningful, lasting results. Next slide, please, Catherine. And then just sharing with you how it all kind of fits together. So we've got, as part of our solution, we offer the full life cycle of the employee for the employee, and that's the recruitment. We've got onboarding software. Knowing how customers like to manage payroll, we also offer payroll software as well as payroll bureau. We offer consultancy. We've got a benefits platform, so bringing everything holistically into one place. And we also offer e-learning platform and e-learning content as well. Needless to say, our system supports APIs, so that does mean that we can integrate with other business systems that you are using. That's a little bit about Ciphr. If you do want to know anything more at the end of the session, please do reach out and I'll be happy to answer any questions. Handing now over to Stuart.
Fantastic. Thanks, Sarah. Good morning, everybody. Ever so slight change to, I suppose, our normal program for you. Often we do a look at what's on the horizon, we look at legislation updates, and there's always case law updates. But I think for the purposes of today, we're going to focus on some really practical cases. There's been, last time we spoke to you, we do these things every 6 months. There's been lots of cases in 6 months, but we wanted to really focus on, drill down into some really practical cases that we think are likely to impact on many of you, rather than maybe some of the drier, more techie cases that have been reported over the last 6 months. And then in relation to what's on the horizon, Catherine said a deep dive into the Employment Rights Bill in 40 minutes. There you go, Sian, there's a challenge for you, but we're going to try and cover as much detail as we can in the time that we've got allotted. But so I'm going to go straight in on to the case law update. The first case is the case of Stedman. In fact, my first two cases are all about disability discrimination, which is quite timely, given that last week I was training a client in relation to disability discrimination. So I think the starting point is to remember that proving whether or not you have a disability is generally considered to be it's a low threshold, it's a low bar that a claimant has to overcome. And the case looked at someone who was neurodiverse. And I think at that point, I'd like to pause and say it's probably worth mentioning that we often like looking at tribunal statistics. And there's been a recent statistics that's shown that cases of disability discrimination involving claimants who claim to be neurodiverse have seen an increase of 50% since 2020, an absolutely astonishing number of cases that have seen an increase in. One stat has suggested that I've seen that 15% of all of the workforce, all of employees are neurodiverse. ACAS put that figure at 20%, and it's now the case that referrals in relation to neurodiverse employees account for the third most common referral to occupational health. So the facts of this case are relatively straightforward. Mr. Stedman applied for a job. He had a diagnosis of autism spectrum disorder, ASD, and attention deficit hyperactivity disorder, often referred to and shortened to ADHD. He didn't get a job, and he brought a claim for disability discrimination relating to the recruitment process. At the preliminary hearing, or at a preliminary hearing, he relied on an impact statement setting out his difficulties in social interaction, with memory, with concentration, and using public transport. And being required to provide a disability impact statement is something that you may have come across. It's something that tribunals regularly order. So the judge took into account his oral evidence, which included the fact that he'd undertaken a degree, he had friends, and the tribunal accepted that he had a mental impairment, but concluded that the disability didn't have a substantial impact on his normal day-to-day activities, and so it didn't satisfy that, and so his claim fell at the first hurdle. He appealed on a number of bases, and I want to go into those. I'm not going to explain the answers in relation to each of them, but I want you to understand the basis upon which he appealed. So the first thing was that he appealed and said that the decision was perverse based on a psychiatric report that he had relied upon that confirmed that he'd been diagnosed with these two conditions. The second point was that they said they wrongly failed to recognise the substantial adverse effects on his ability to carry out day-to-day activities, and they'd failed to consider sufficiently whether or not they were substantial. They also said the tribunal hadn't taken into account properly what he'd set out in his impact statement. And finally, they said the tribunal had been incorrect because they had focused on what he could do rather than what he couldn't do or could only do with significant difficulty. And that was contrary to the government's guidance on matters to be taken into account. So if any of you have been to tribunal in relation to disability claims, you may be aware that the reference point for this is a book called the Equal Treatment Bench Book. And basically what he argued was that the tribunal hadn't taken that into account. Now the appeal was allowed, and that's the headline comment. He was successful in overturning the tribunal's decision. But I want to go and drill down in just a couple of really key points here. One, in relation to the perversity point, you'll remember that was about the report. They basically said that actually the report that was being relied upon by Mr. Stedman wasn't written by an expert. It provided little explanation as to what his diagnosis was. And basically what they said was that he didn't satisfy the definition of disability just because of what the report said. And the EAT said that it was right in those circumstances for the tribunal to focus on the impact statement. Why have I flagged this? Well, I suppose I'm flagging it because the simple fact that somebody is diagnosed with one of these conditions is not in itself sufficient to meet the definition of disability. But in relation to substantial adverse effect, the EAT said that the tribunal had failed to keep in mind the fact that the required statutory comparison should have been between Mr. Stedman's abilities as they were with the impairment in comparison with what they would hypothetically have been without it. They accepted the fact that they didn't consider sufficiently if he experienced substantial adverse effect on his ability to carry out just one day-to-day activity. And that's absolutely crucial. I'm going to come back to that in a second, but just one day-to-day activity. And they also said what the tribunal did in the first instance is they tried to weigh up all of his abilities to do day-to-day activities to come up with a global decision about whether or not he was disabled. And they said, no, that's incorrect. So basically, what I want to stress here is that if an individual is unable, a single day-to-day activity will be sufficient. If a disabled person or person alleging disability can show that they are struggling with one single day-to-day activity, that will be sufficient. And the key point here is that in these sort of cases, a claimant has to satisfy each and every constituent element of the definition. Tribunal it will make a decision in its own right as to which way it will address it and think about all of those points. But if a claimant fails on any one single element of that, their claim will fail. But if the tribunal fails to properly address its mind to each of those, then it opens its mind it opens the door to the possibility of an appeal. So that's the first disability claim. The second claim is the case of Hindmarch, which is another, as I say, it's another disability discrimination claim, but it looked at the duty to make reasonable adjustments. So before we go into the case, let's just go back in time a little bit. Under the Disability Discrimination Act 1995, I can't see you all, don't know how old you are, but I can certainly remember that very well. But that actually set out expressly within that the factors that would be taken into account when determining whether or not something amounted to a reasonable adjustment. So that included, at that time, under the 1995 legislation, the extent to which it fixed the advantage, how practical the reasonable adjustment was, the cost and disruption to the employer, the financial resources of the employer, the availability of assistance, whether or not that's financial or other, and the size of the employer. So apologies, big employers out there, the bigger you are, the higher the expectation. Now that's not been replicated under the provisions of the Equality Act, but it is set out under the HRC code as factors that might be taken into account. In relation to factors that are or do need to be taken into account that are established by case law, the first one is whether or not the adjustments will work. Arguably, that's the most important factor and the one I'm going to talk about, costs and the effect on the workforce. So a couple of points to stress. The first one is that if an adjustment doesn't work in the sense that it's not going to alleviate the disadvantage in question, it doesn't matter how big or small the employer is or how inexpensive or expensive the step's going to be, as the adjustment would be futile, there's no point, it doesn't amount to a reasonable adjustment. And a case law has previously established that an employee does not need to show that an adjustment would work, just that there was a chance that it would work. So, and that case really endorsed that principle, and it's a really useful reminder of that last point. So the facts are on the slide. The claimant was an ambulance driver during the COVID pandemic, and he refused to return to work unless he was given an FFP3 mask rather than an FFP2 mask that was normally issued and was issued in accordance with government guidance. The employer refused. They referenced the national guidance on the basis that FFP3 mask wouldn't automatically alleviate and provide complete protection. And they said, well, actually, on that basis, we don't think that it will alleviate the claimant's extreme anxiety. And the claimant, actually, he didn't ever confirm that he would return to work if he was given one of these masks. He was dismissed on capability and brought claims of various claims, including a failure to make reasonable adjustments and unfair dismissal. But his claims before the tribunal and the EAT were dismissed on the basis that if there is no real prospect of an adjustment helping to avoid or reduce the disadvantage suffered by the disabled employee, then the employer is under no duty to mitigate it. So what's the learning point? If you can look at an adjustment or an alleged adjustment and say, actually, it's not going to resolve the disadvantage, then there will be no need to make that useful reminder. Okay, so from disability claims to a disciplinary hearing. Really interesting case for anybody who uses external HR consultants for grievance and disciplinary processes. I know a number of our clients do. And on this one, I'm going to jump straight into the facts, try and keep up with the number of respondents, because there's a lot of respondents in this case. So in this case, the claimant was an employee and a director of the first respondent, and the second and third respondents in this case were co-directors. The claimant, so the director, made allegations of financial impropriety relating to the running of the business, and then members of staff raised a counter grievance against him, alleging bullying and harassment. And then, because of the seniority of everybody who was involved, the company appointed an HR consultant who became the fourth respondent. He was retained by the company to investigate the grievances, and he found that them to be substantiated, and he recommended a disciplinary hearing. Again, because of seniority, the company appointed another HR consultant who was retained to conduct the disciplinary hearing. And that HR consultant produced a report stating that the company would be justified against dismissing the claimant for gross misconduct. He didn't actually make the decision to dismiss. He recommended that there should be dismissal, and he was dismissed. And he brought claims against the company for unfair dismissal, both ordinary and having made protected disclosures. And then he brought a raft of claims against the second right up to the fifth respondent, and he claimed of detrimental treatment on the grounds of having made protected disclosures. And his claims were against the HR consultants on the basis that they were acting as agents of the company, which is something that's protected under the Employment Rights Act. And his references in relation to detriments were in relation to the fact that he'd been suspended, that he'd been removed as a director from Companies House, and that ultimately he'd been dismissed. He basically referenced the fact that there was evidence that the company had control over the two consultants, but the tribunal in the first instance struck out his claims against the two HR consultants on the basis that they weren't acting as agents. And they submitted, the HR consultants submitted, that an agency relationship would not have existed as their remits had fallen short of basically having a power to affect the legal relations between the claimant and the company. So he said, look, we didn't make the ultimate decision to dismiss. So in the context of establishing agency, which is a really important point, what the EAT said was that the power to affect a legal relationship between parties was not an essential requirement to exist, although it was one of the hallmarks of an agency. The key issue was whether or not the services provided related to a significant aspect of the employment relationship rather than some other aspect of the employment business or activities. So a person who was retained to carry out employment-related procedures, such as a grievance or disciplinary procedure, could be regarded as the employer's agent, but it wasn't automatically the case. And what they said, it would go to the degree of control, the degree of direction or constraint, and the extent to which the appointee was subject to whether or not they're an agency. So in this case, the claimant hadn't argued that the HR consultant had been involved in the actual dismissal, or that the other HR consultant had taken the decision to dismiss. It was held that the fact that the company had relied on the investigation process carried out by them didn't mean that either of the HR consultants were co-liable for the dismissal, nor that they should be deemed to be acts, and therefore it was held that there was no claim against the HR consultants. So we're very conscious, both Shana and I are very conscious, that very, very occasionally HR consultants are instructed to go further than just carry out the investigation. So they're actually the decision makers. And I think that's probably where the agency risk would be far higher. It's far more preferable if you limit your instructions to HR consultants such that they're just doing the investigation. So that was an interesting case. Next one for me is actually a far shorter case in relation to practicalities of tribunals and just getting claims struck out. And I'll share with you what Sian and I are seeing at the moment. The team that Sian and I work in, we do a broad range of work, from corporate support work to business as usual work to immigration to the full remit. We're not historically, we haven't been a team that does an absolutely massive amount of tribunal work. We've always done a lot of tribunal work, but not a massive amount. I suppose on average, we've only got a few of us within the local team. There's 55 of us nationally, but we probably run 12 cases at any one time, probably on average. We've got over 30 at the moment, and I think that's reflective. It'd be interesting to understand in the comment boxes as to whether or not anybody else is seeing an increase. But tribunal claims can be very frustrating to deal with, but they can be blooming frustrating. I was very careful with the word I use there. When a claimant, particularly a claimant in person, doesn't comply with a direction, Sian in particular, likes to apply lots and lots of pressure on claimants to try and get them either to withdraw their claim or to settle for peanuts, but it can be particularly frustrating when they don't comply with directions. And clients will often ask us, well, actually, look, the claimant hasn't complied with this direction, this is their claim, can't we get it struck out? The facts of this case, I'm not going to go into too much detail other than saying that the claimant missed not one but two deadlines in the context of complying with an order, and the employment tribunal basically struck out the claim on the basis of lack of compliance. But the EAT, when it got to the EAT, they said, no, that was too draconian, and they shouldn't have gone to strike out in the first instance. And what they should have done is actually given the order, made what's called an unless order. What's an unless order, I hear you say? Well, it's a bit like that famous wood stain that was always advertised on the TV. It does exactly what it says on the tin. It's an order that basically says, unless you do this, then these are the consequences. So unless you actually comply with that order, your claim will be struck out. So sorry, everyone, it's going to be a lot harder to get applications for strikeout. Not to say we can't get there, but our team is now applying for unless orders in the first instance before going for strikeout. Still trying to be as proactive as possible, but not going straight in for the jugular as far as the strikeout is concerned. Okay, penultimate case for me is the case of Wilson. It's an alarming case involving group income protection. Useful reminder that no matter what you might think, you've still got to follow due process. I never get more nervous than when it's a case involving group income protection, and I never get more nervous when I'm advising on those, because you get those cases wrong, huge potential liability. And this was a case where an employer took a really bold approach, and the HRD took matters in their own hand, he says with a smile on his face. Facts of the case are on the slide. Mr. Wilson was employed as a warehouse operative, was diagnosed with a condition that affected his spine. It was recognised as a pain disorder. He was absent for about 15 months. He had chronic pain and mobility issues, and despite an MRI showing no abnormalities, the tribunal accepted the diagnosis, and it had an impact on his daily life. He had the benefit, as I say, of this income protection policy through Unum, which initially provided cover. But the HRD didn't believe him and conducted social media checks, instructed covert surveillance. And based on this, she unilaterally told Unum to cease income protection payments to Mr. Wilson, believing he was exaggerating or fabricating his decision. He wasn't informed of the surveillance until a later meeting, which the tribunal found was misleading, because it was described as an informal welfare meeting, and the decision makers were not shown the surveillance evidence and were basically instructed to disregard concerns in relation to fraud. I'm going to pause at that stage. As I say, I'm always very wary about group income protection claims. Got to be really, really careful about surveillance. I've only ever, I think, once or twice ever advised where I think there's genuine merit to put in place covert surveillance. Our experience is that tribunals really don't like misleading meetings, so naming something and when it actually is something else. And as I explained to an American client earlier this week, always go back to basics. In order to avoid a claim of unfair dismissal, you always need to have a fair reason and you need to have a fair process. And the tribunal in this case found it to be both procedurally and substantively unfair, and basically found that the tribunal the company had failed to consider reinstating the insurance payments or exploring reasonable alternatives to dismissal, failed to take into account updated medical evidence. The only good news in this case was that there's no finding of direct discrimination or harassment. But please, 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 no matter how much you don't believe an employee's position to be, please make sure you follow due process, because otherwise you are definitely going to be looking down the barrel of an unfair dismissal claim, and depending on the circumstances, a potential claim of disability discrimination. Right, last case for me, really quickly, one of my favourite subjects is TUPE, a case involving MAC recruitment. So as I'm sure you're all aware, TUPE can apply in one of two cases, so where you're looking at a transfer of undertakings or a part of an undertaking, or in relation to a service provision change. Not all service provision changes will trigger TUPE, and you need to satisfy, in the context of SPCs, as they're often shortened to, Regulation 3 conditions, all of the Regulation 3 conditions, and with one of those being whether or not there's an organised grouping. And the exact wording of the legislation saying there needs to be an organised grouping of employees situated in Great Britain, which has as its principal purpose the carrying out of activities concerned on behalf of a client. So there's lots of case law about what amounts to an organised grouping. And there's a really famous case involving Eddie Stobart. Lots of employment tribunal claims involving Eddie Stobart. He doesn't tend to like employment law that much, but basically the famous SPC case involving Eddie Stobart basically confirmed the fact that to be an organised grouping, it needs to be quite deliberate and structured. But this case shows that actually tribunals can be a little bit more open about what amounts to being organised grouping. So facts again very quickly. The claimant was employed by G Staff and later by MAC Recruitment. Both were employment businesses supplying workers to butchers' pet care, and she worked consistently as an operative. And the company argued that basically the grouping in relation to where she worked was incidental based on how the shift patterns fell. There was nothing deliberately organised, and that the tribunal relied too heavily on her testimony at the first instance. But the claimant basically said actually there was consistent working patterns. The team composition was basically supported the argument there was an organised grouping. And the tribunal found actually in this situation there was a settled group of employees. It was consistently in place, and it rejected that there needed to be any sort of formal organisation on behalf of the employer, and there was no need for there to be any conscious decision making. And an organised grouping can exist even where there is some flexibility and ad hoc arrangements. So yeah, it was an interesting case. I think it's moved the Eddie Stobart case on a little bit further along, and basically a settled group of employees can amount to organised grouping. So slight shift, one to be very aware of if you're looking about the application of TUPE, and it will, as ever, be very, very fact and evidence specific. That's it for me for my rattle through my case law. Sean, I think I'm just about on time. Over to you for the Employment Rights Bill.
Thanks, Stuart. Morning, everyone. So I've got the joy of updating you all on the Employment Rights Bill in half an hour. So I don't know, for a lot of you, you might have found it a bit of a struggle in the last year to keep up to speed with the many proposed amendments that we've seen coming through. So just moving on to the next slide, please. Yeah, excellent. So yes, as we know, the Employment Rights Bill is a vast piece of legislation with over 28 major employment law reforms. Since last October, it's gone back and forth between the House of Commons and the House of Lords, with well over 200 amendments having been proposed. So it's not surprising we found it hard to keep up with it. Where there have been government amendments, unsurprisingly, they've largely accepted their own amendments. When there have been proposed non-government amendments, they have largely been rejected. So where are we now? On the 15th of September, the bill returned back from the House of Commons to the Lords, and they're likely to now approve the bill in its current form on the 28th of October, and we're expecting to receive royal assent in November, so not long now. The government has now published its roadmap for implementation. You'll be pleased to know that it's not going to do everything all at once, and it's going to have a phased approach. Still, there's a lot of consultation be done, policy decisions, and some will still require secondary legislation, and that's all expected to be happening from now until early 2026. Some measures are going to take effect immediately. Well, just the repeal of the minimum service levels in relation to industrial action, which the Conservatives had implemented. And shortly after royal assent, we will see some other trade union provisions coming into play. But on the whole, most amendments are going to be in a phased approach from April 2026, which isn't far away at all, October 2026, and then some provisions will be sometime in 2027 on dates that are unknown. So if you do want to have a look at those exact dates, do have a link that I've shared on this slide in relation to that implementation timetable. Also on the slide there, just sharing our link to our Employment Rights Bill hub on Shoosmiths website, where we're keeping you up to speed on all of the changes, and we've got some webinars and just takes a deeper dive on some of the subject areas there. So do take a look. Right. Let's see what's changed since we last delivered this update, and just recap on some of the main provisions. So as you currently are aware, I think we might have just skipped a slide. If we can just go back one. Yeah, there we go. So unfair dismissal was top of the headlines. So yeah, as we know currently, in order to qualify for unfair dismissal rights, you need 2 years continuous service. And what the bill is going to do is implement from day one unfair dismissal rights, where you don't need any qualifying length of service to bring such a claim. There are some caveats that I'll come on to, but this change isn't now going to be introduced until sometime in 2027, probably the latter end with how things are going at the moment. So we've got a bit of breathing space on this one. The Employment Rights Bill is going to allow for regulations to modify the right not to be unfairly dismissed with a light touch procedure that can be followed, basically where the dismissal occurs during what's referred to as initial period of employment, or where the employer gives notice of termination before the end of that initial period of employment, and the effective termination date is not more than 3 months later than that end of that initial period of employment. So what is this initial period of employment? Unfortunately, we still don't know that. That's what they'll be consulting on further. There's been speculation and preference on it being around 9 months. So arguably, with the kind of provisions as they are, provided you give notice before the end of that 9 months and that end date isn't more than 3 months past that initial period, it could be up to a year before an individual has their full, I guess, unfair dismissal rights. So what does light touch look like during this initial period of employment? Well, again, sorry, we haven't got any further forward on this. There have been, the government's suggesting that it is likely to be a meeting with the employee to explain the concerns. And I think that's good news, in that I think most employers will, regardless of length of service, go through some sort of short service dismissal anyway already, just so that they've got a paper trail to evidence what the real reason for dismissal actually is. So things might not change too much there. As to whether there'll be a requirement for this to be in writing or not, we don't know that yet, but we would certainly recommend that as best practice. Again, just part of the paper trail, and to the extent the individual is uncooperative and failing to attend, at least we can evidence that we attempted to meet with them. So yeah, managers are certainly going to need to be aware of these different processes that need to be carried out, depending on whether they're in this initial period of employment or not. And training will need to be provided there. And what's also interesting is that this light touch procedure is only going to apply in relation to where the dismissal, or the principal reason for the dismissal, relates to the individual, to the employee. So to the extent it's about capability or conduct, illegality, or some other substantial reason where it relates to the individual, i.e. breakdown in trust and confidence, third-party pressure, then you can benefit from this light touch procedure. If, however, the dismissal doesn't relate to the individual, i.e. redundancy situations, end of fixed term contract, there are multiple SOSRA, some other substantial reasons that don't relate to the individual, change in terms, conditions, firing and rehiring, where from day one you will need to go through a full procedure as you would do anybody else with qualifying length of service. So again, managers are going to need to be on top of differentiating what type of dismissal it is as to what procedure that needs to be followed. In terms of what the compensation might look like during the initial period, to the extent we fall foul of this light touch procedure, the Secretary of State will be able to set that cap on compensation, and we certainly hope that it looks less than the 118,223 that it is currently in relation to normal unfair dismissal compensatory awards. So how is this going to impact you? Well, we've already flagged that, managers are certainly going to need to be aware of the different processes that need to be followed out depending on the type of dismissal. Probationary periods are certainly going to have to be used a lot more effectively from the get-go. Sadly, I think employers are going to obviously need to be forced to make decisions a lot earlier about an individual's suitability for the role. There's certainly going to be more cautiousness with recruits, which is never good, especially with unemployment continuing to rise. And I think employers are going to be more reluctant to, take a risk on unknown individuals that possibly don't have experience. And so this is going to likely impact, our younger workforce who are already struggling to get into employment. So it's likely to have an impact on diversity initiatives. And we're likely to see more unfair dismissal claims coming through to our already inundated tribunal system. Certainly, it would be recommended to make sure that you've got robust recruitment processes in place so that we are getting recruitment right, which is always what I'm sure you're endeavouring to do anyway. So the next bullet point on this slide just flags quite a big amendment that the government forgot to put in their first draft of the bill, where they are increasing time limits for all employment tribunal claims from 3 to 6 months. And that's coming into force in October 2026. Many of you will be aware of the long discussions that have been had about increasing time limits, particularly for discrimination claims, whistleblowing claims, where the individual might be off on long-term sick or on maternity leave, or just trying to resolve the dispute internally in the first instance. And we know how quickly 3 months can disappear. So yes, that there was that aspect that needed addressing. I think the issues here are that, yes, we're likely again to see a potential rise in tribunal claims. Trying to see the positives, it's going to give more time for employers to try and resolve the disputes before a complaint is lodged. Downside is that obviously final hearings are going to be even that much further down the line, and at the moment it could be a year before we even have a case management hearing with our current system, and probably 18 months from when the claim's lodged before we get to tribunal. So that's just going to be pushed even further down the line. And it's really hard because, witnesses move on, their memories fade after that period of time. And so employers are probably going to need to start ensuring that they've got, if you've got threatened litigation, your paper trail is always important. It's going to be ever more important. But whether you try and capture witness evidence a lot earlier on now as well. So moving from that joy to collective consultation, you'll be familiar that last October there was a lot of uproar where the bill was going to remove the one establishment test for collective consultation, such that collective consultation would be triggered where an employer proposed to dismiss as redundant 20 or more employees within a 90-day period across the whole organisation. And the impact of removing that one establishment test was going to be that for multi-site organisations that were just making pockets of redundancies all the time across their sites, they could have almost been in perpetual collective consultation. So the government listened to that. That proposal's been dropped. However, they are going to introduce a new trigger for collective consultation alongside this existing trigger, which does look at proposed dismissals across the organisation. That new trigger for collective consultation will be set at a higher number than 20 employees, thankfully, but we don't have yet an indication on what that trigger is going to look like. Is it going to be a percentage of the workforce? We don't know, and obviously that's going to be key to understanding the impact this is going to have on your businesses. With this new trigger, there is also a new section into our TOLCRA legislation which requires the employer to disclose in writing to appropriate representatives the total number of employees it's proposing to dismiss and details of the establishments in which they're employed. So you'll be aware for TUPE consultation and collective consultation, there's set information and consultation obligations. As part of that information exercise, that bullet point list is going to look slightly longer. Interestingly, the government has included provisions within the bill to allow employers to consult appropriate representatives separately on a site-by-site basis with a view to reaching different agreements with different groups, recognising there might be different issues there. And that should hopefully help employers where the trigger is across the whole organisation. Another flag is that they are aligning the period that you need to notify the Secretary of State with your HR1 form, depending on what the consultation period is. So for where you're proposing to dismiss more than 100 employees, you've got a 45-day consultation period, and you'll need to notify the Secretary of State with your HR1 form 45 days in advance of that first dismissal. And then it will still be the case where it's less than 100, more than 20, you've got a 30-day consultation period, and that HR1 form will need to be sent 30 days in advance of that first dismissal taking effect. So that all makes sense. Make sure that you are familiar with your obligation to notify the Secretary of State, because that's a criminal offence if you fail to do so. So those changes are coming in not until 2027. So again, we've got a bit of breathing space on that. I'll do another, however, which is that a lot sooner, April 2026, so this coming spring, the protective award is increasing. So currently it's a maximum of 90 days actual pay to it's going to increase to 180 days. That's half a year's pay. That's massive. And the government's objective here is that they're going to simply make it far too expensive to buy out employees' statutory rights. They want to make it a case that employers have no option but to comply with the law. Many of the respondents to the consultations that have been carried out today say, well, we don't not comply with our collective consultation obligations deliberately. More often it's the case that they're so complex, we can't follow exactly what we need to do, and we trip up on minor points potentially, and then we're at risk of these protective award claims alongside what will probably be an unfair dismissal and their notice and everything else. So the bill recognises this, and there are provisions for the government to issue guidance on the steps to be taken on collective consultation. I'll be really interested to see whether that comes out ahead of these new rules or not. Right, still on the same slide, just looking at firing and rehiring and what changes we've seen there. So you'll be aware that employers sometimes want to change employees' terms and conditions. And in order to do that, they need an individual's consent. And to the extent they refuse to provide that consent, there are a number of different options available to employers. But one of them, as a last resort, is to contemplate dismissing and re-engaging on the new terms and conditions, and what has become known as firing and rehiring. Lots of controversy over the recent years on this with the P&O scandal, Tesco's, and our last government was very alive to this and put in place a updated code of practice on firing and rehiring that went live last July, and you should already be familiar with, because to the extent you don't comply with that, there can be a 25% uplift on awards. Current government said, last government, you haven't done enough, and they wanted to, in essence, automatically ban any firing and rehiring until they had a little bit of a head scratch on this. I think it was just before the summer, where they're like, oh, hang on a minute, this is going to impact upon us as well, particularly where they're looking to move public servants out of the London areas into the regions and realising they're going to be stuck with these provisions too. So they've snuck in a new clause 26 into the Employment Rights Bill, whereby a dismissal will only be automatically unfair where the employer is trying to impose a restricted variation. And that's currently defined to be a change in pay, pensions, contractual hours or holiday, and any attempt to add in new flexibility clauses on these topics. But all other contractual changes, such as relocation or minor changes to minor duties, will remain subject to the ordinary test that we have at the moment, which is, in essence, to the extent you've got sound business reasons, it doesn't have to be critical to the survival of the business, but if you duly consult and act reasonably, you can dismiss fairly and re-engage on new terms and conditions. To the extent, however, it is a restricted variation, then ultimately that dismissal is going to be automatically unfair unless the employer can demonstrate that it would trigger calamitous financial distress. In essence, the company will go kaput. And in those situations, if that defence is made out, then the tribunals will revert to the normal reasonableness test that I've just referred to in establishing whether they've consulted and got sound business reasons for those changes. They'll be making a parallel ban, whereby making it automatically unfair to dismiss employees to simply replace them with agency workers or contractors will be unlawful unless that same financial distress test is satisfied. And if you are relying on financial distress, you'll need to be able to evidence that financial distress. And so you'll need to think about instructing financial or restructuring experts to be able to give this evidence. And that's just going to, in reality, add complexity to hearings and increased costs. If you are looking at reorgs, be already mindful of the code of practice I referred to already. But yes, I think in essence, a lot of our clients certainly are trying to get ahead of these changes and looking at what they need to do now. These changes are coming in October 2026. 0-hour contracts. So just moving on to the next slide there. Not too much has changed on this since last October. You'll remember them wanted to make such contracts unlawful, but didn't quite get there. But instead, in essence, there's going to be this requirement to offer those that are on 0-hour workers, or those that work a low number of hours but regularly work more than those hours, the ability to basically be offered a set minimum number of hours per week on set days and times. So in essence, guaranteed hours. That's after they've been working for you for a qualifying period of time, and they'll look at a reference period. All of those provisions are yet to be defined, so we need to find out what those low hours look like, what the reference period is going to look like, what the qualifying period of employment is going to look like, and the government's going to continue consulting on that. Alongside that, the bill also gives workers, we're going to be obligated to give reasonable notice of change in shifts, and to the extent we don't, there'll be compensation available to those individuals who have had cancelled or shortened shifts at short notice. So yeah, I mean, quite often that's the whole point of why you'll use 0-hour workers in the first place. We don't know what that compensation is going to look like yet. And certainly I think for a lot of business, they'll say, goodness me, there's so much red tape in this, trying to work out reference periods, qualifying period of employment, and the obligation will be on the employer to offer it, not the individual to request it. The individual can refuse it. So with all of that kind of rigmarole, I think certainly employers are going to have to consider just offering more than those low hours in the first place to a certain population, and that population is going to be a much narrower pool than what you are currently using. So again, that's not going to be great for diversity. Employers are going to contemplate if they can use fixed term contracts, but there are anti-avoidance provisions in place, and fixed term contracts can only be used where there is that genuine need, and it's quite limited as to whether there's a specific task or occurrence or demonstrating you've got that seasonal fluctuation and that temporary need. One of the key changes since last October is that agency workers are going to be caught within the scope of these provisions. So even if you don't use 0-hour workers, to the extent you use agency workers, you need to be aware of this legislation. And the responsibility will fall on the hirer. Well, it depends on the provisions, actually. Sometimes it will fall on the hirer, sometimes the agency worker. And yeah, again, it requires a much deeper dive into the provisions there to fully get up to speed on that. There will be requirement for you to notify employees about what their rights are under the Employment Rights Bill in this regard. So yeah, employers are going to need to review their business models and what their needs are going forwards. I think it's very dangerous time, really, where we want to grow our economy. I think employers are going to be that much more reluctant to be offering overtime, and that's just going to, dampen growth and productivity, or put, more pressure on your existing workforce that might already be stretched. Right, on that happy note, I'm moving on to harassment, which again, I think that it all follows similar themes here. Just flagging in relation to sexual harassment, that last October, we saw a new positive duty being introduced on employers to take reasonable steps to prevent sexual harassment in the workplace. So that's been in play a year now. We have seen ourselves an increase in sexual harassment cases. ACAS has seen that increase. That's probably through increased awareness. This is something you already need to be on top of. The HRC did publish its eight-step guidance on what you should be doing to ensure that you are taking reasonable steps to prevent sexual harassment, and it's also published more in-depth guidance for certain sectors such as hospitality, which is also worth looking at, just by way of seeing what examples they've got there. So that was last October. The Employment Rights Bill is going to enhance that duty further, and this is going to be from October 2026, where there's a requirement to take all reasonable steps to prevent sexual harassment of employees, and that's including by third parties, and that's going to be what's really onerous for employers. So the regulations are going to specify what these reasonable steps look like. In relation to the liability for third parties, which is obviously going to be of massive concern to employers, because it's hard enough to control the actions of our employees, let alone external third parties, particularly in customer-facing industries such as hospitality and retail. But I think the frightening thing here is that with the third-party liability, you don't need to have any knowledge of the harassment. It can be from that very first act that you're caught out, and liable in essence for that harassment by third parties. And the only defence is if you've taken all reasonable steps, which is a very high threshold to meet. Interestingly, with the Employment Rights Bill, this is in relation to sexual harassment, these provisions, and they haven't extended it yet to other protected characteristics. So we wait to see whether any amendments will be made there. It will become the case that any report of sexual harassment automatically will now qualify under the Employment Rights Bill as a protected disclosure. And then what's also recently been introduced is a new clause 22A to the Employment Rights Bill in relation to non-disclosure agreements, and essentially banning them where it involves harassment and discrimination. So that's a relatively new amendment, and it will void any non-disclosure agreement or confidentiality clause that attempts to prevent a worker from making allegations or disclosures on harassment or victimisation. And it will apply to employment contracts, settlement agreements, standalone NDAs. So the question will be, well, do you want to pay that great sum of money if an employee can still, talk about it? And I think, yes, to the extent you want to kind of put to bed any tribunal claim, you might, but what is going to be really important with any settlement agreement in COT3 is always without admission of liability anyway, but you will want to make sure that you've carried out adequate investigations when these allegations are raised, such that you can rebut them, and you're still not accepting that these allegations have necessarily happened if that is the case. There is said to be a ban, in relation to this ban, there will be accepted agreements. We don't know what accepted agreements will look like yet, but the suggestion is where the NDA has been requested by the individual. Right, so going on to some family leave provisions. You'll all have heard of some day one rights being introduced in respect of paternity and parental leave. So it used to be 26 weeks service, or it still is, and a year's service in relation to those rights, but they're going to align them to other family leave entitlements that are a day one right, such as maternity and adoption leave. So you'll need to make sure that you are on top of that. Which will require changes to your policies. The government will also be widening the new right to bereavement leave, also as a day one right. And it's going to be extended to include pregnancy loss before 24 weeks, which again, the implications of that could be quite wide ranging, in the sense that it could be anybody that's going through, IVF, and miscarriages at a very early stage. What evidence will you request from employees, if any, in that regard? Whether it will be taken up, I don't know, because it's going to be an unpaid entitlement there. Another flag is in relation to statutory sick pay, and they'll be removing the lower earnings limit and the waiting period there that you'll be currently familiar with. And so again, it's just making sure your payroll and your policies are updated in that regard, and aware that Ciphr are running a session that looks at what you need to be doing here to plan for these changes. Catherine, you might mention a bit more about that at the end. And then also another flag here is that the Employment Rights Bill will be strengthening the protection for pregnant women returning back after a period of statutory family leave, making it unlawful to dismiss employees who've been pregnant within 6 months of their return to work, save for very specific circumstances. So we await the regulations to see what those specific circumstances will look like. Flagging another change on the slide there in relation to flexible working request, the Employment Rights Bill will introduce this new test of reasonableness when refusing a flexible working request, which we don't currently have it now. The companies had much of their own discretion based on business needs to reject those requests. So it will mean that employers do need to have more objective evidence as to why it isn't reasonable to accept that request if they are going to refuse it. I think, yeah, what's interesting is that they're not changing the compensation for failure to comply with our flexible working regulations. So that's currently 8 weeks pay. So yeah, there's talk here that actually there's very little teeth to this statutory scheme. But whilst that might be the case in relation to claims that directly fall out of a failure to follow your flexible working rules, the sting in the tail is always more so in relation to the discrimination claims that you're likely to receive as well, and potentially constructive dismissal claims to the extent they resign. So we'd always recommend that you act reasonably when refusing a flexible working request and have objective evidence. And it helps with the individual's understanding ultimately, doesn't it, as to why you have refused it. Another just small flag there in relation to flexible working requests changes, don't know, probably over a year ago now, just making sure that you've only got 2 months to deal with flexible working requests, including the appeals. So not to sit on them and make sure that you do deal with them promptly. Finally, just in relation to trade union legislation, mentioned we'll have some changes coming in very quickly on royal assent being received in relation to the repeal of the minimum service level provisions. You could do a whole session on trade union provisions, aware that many of you it won't be relevant to. What I just wanted to flag today, which will be relevant to lots of you, well, all of you, in fact, from October 26, there will be a requirement to provide a statement to employees of their trade union rights. And we anticipate that can be built into your contracts of employment in your Section 1 statement. Also a flag in relation to the access to workplace agreements, that's also coming in from October 2026, whereby you'll have to agree rights of access with trade unions to meet with your members, recruit new members, support with collective bargaining. So yeah, it'll be quite interesting to see how that develops and the further consultation that follows on this and the means in which they can access your workplace. Also noting that the Employment Rights Bill is going to streamline significantly the statutory recognition process. So it is going to become a lot easier to strike. So with strike season upon us, I'm sure that won't necessarily be good news. So it's a bit of a whistle stop. They are the key changes. There are a lot of changes at the moment, but we just wanted to leave some time for questions.
So much, Sian and Stuart, for that whistle stop deep dive, because I think it's both. We've covered a lot of ground this morning, but we've done it quite quickly. So yeah, we do have time for your questions now. I know Antonia has been diving into the chat and answering some of them. Antonia, are there some things that you want to highlight that people have been talking about?
Yes, we've had quite a lot of questions around the date, which is something that we always get with this topic. When is it actually going to come in? So I've been trying to answer some of those, but Key ones are, I think, the 0 hours, low hour worker provisions. They're not due to come into force until 2027. I think the government has recognised how much work needs to be done to get ready for those changes. We don't have a date in 2027. If you look at the implementation plan, we've shared the link to it. It just talks about it being in that year at some point. But I know the government is trying to use April and October as kind of dates for bringing things in.
There was one question, Antonio, on the feed about the joy of trade unions, and we've had the question: are these changes going to apply if the business doesn't recognise a trade union? And I am afraid the answer to that is yes. Certainly, as a national team, we are looking at that we are fully expecting that we're going to need to give an awful lot more trade union advice going forward, and we're looking at working out how we're going to upskill and make sure that we're prepared and ready for that. We've already got one trade union who has been gently sniffing around one of our clients for a while, and they are, let's just say, they're sniffing a lot harder at the moment, almost on anticipation. And I think you've got to think about, I'm conscious that there's lots of people on the webinar this morning. You've got to think about whether or not you are in a sector that is likely to be targeted. Obviously, some sectors are targeted more than others from a union perspective, but yeah, I'm afraid obligations in relation to what you've got to provide within your likely to be in your contract of employment. We're not quite sure how that's going to materialise yet, and then all of the workplace agreement entitlements or access entitlements is going to apply to you all, I'm afraid. Sorry.
And the whole point is that the government wants to support unions getting more membership and more recognition and more influence in the workplace. So that's what these changes are all geared towards. We've had a question about updating handbooks, contracts, and I think that's definitely something that needs to be on your radar. I think it's difficult at the moment because until we get those implementing regulations that Sian was talking about, it's difficult to know what the actual detail of a lot of these rights will be. We've had some questions around the initial period of employment and what a kind of a probationary process would look like in that initial period. And again, until we get those implementing regulations, the government has said they will set out in the regulations the type of process to be followed, and it's likely to involve a meeting at which the employee can be represented. But there may be more steps that get added in, and until we see that, those regulations, it's difficult really to get the detail and then to know what it is you need to update. So it's definitely one to be on the radar that you'll need to do it. I think it's a bit premature at the moment.
Yeah, and Sian and I hosted an HRD roundtable earlier on in the week on this topic, and it was really interesting to hear how people were either reacting or still playing the waiting game in relation to this. I think we are beginning to get some clients who are contacting us for reviews of probationary period wording, etc. But I think the most interesting point that came out of that discussion was there was one reasonably large employer who had taken the decision to move away from probationary periods, and they have already started to bring it in so that they're beginning to change, I suppose, the culture and the approach, so it doesn't come as a sharp snap response at some point next year. So they've actually brought probationary periods back to the table.
Yeah, I think a lot of clients probably be looking at 6-month probationary period as opposed to 3-month probationary period, with the option to extend it for a further 3 months to the extent it does mirror that 9-month initial period of employment. But until we know what it does look like, who knows how useful that will be. But I think generally at the moment employers are kind of tending to go for a 6-month probationary period with the right to extend it.
And just to clarify around the day one right, so day one right, so for example, the right to unfair dismissal, that happens from the first day of employment, not the end of the probationary period. All that the government is trying to do is to say, okay, we recognise if you've got your day one unfair dismissal rights, so the day you start your employment, we're going to allow employers to have a period where they don't have to go through as many hoops in order to effect a fair dismissal as they will do once the probationary period is finished. But that right comes in from the first day.
Fab. We've had a question about whether or not there's actually a need for an employee handbook if you have a system that have policies that employees can get access to. No, there's the good news here. Let's give you some good news towards the end of the session. There's no legal obligation to provide an employee handbook. In fact, there's no legal obligation to provide many of the policies that many of you have actually got in place. It's best practice to do so, obviously, from a Section 1 particulars perspective. There's specific obligations with regard to disciplinary and grievance, and then in some areas of law there are obligations to provide things like employee privacy notices, but everything is optional, so there's no absolute need. But if you have got a handbook, then obviously there are, what we're not expecting here is that there will be a requirement for wholesale amendment to lots of your policies. As ever with these things, a lot of this is not new law, but it's going to be fine-tuning of your policies that you've got in place.
We just had one question here about when the April changes, so the changes that are coming in from April next year, when are they going to be published? So according to the implementation plan, the government has promised us various consultations on these new rights that will take place in autumn 2025 and winter 2025.
Already past the autumn.
Yeah, I would say we're getting quite well advanced in autumn. So, but yeah, I suspect that they will try and bring out some consultations as soon as the bill has had royal assent. So I'm anticipating we'll start to get some more information from kind of November onwards.
And probably final question that we've got time for, I don't know, is, because Catherine, I think you want to say some final words. We've had a question about the joy of flexible working requests. I say the joy of flexible working requests, not in any way negative towards them, but simply because Sian and I are dealing with a couple of companies at the moment that are undergoing or very much revisiting what is being required from an office attendance perspective. Some of those processes are going better than others. You get the communication wrong. We've got one client that is, believe it or not, currently dealing with 72 flexible working requests, and it's drowning their managers and HR team. But the question is whether or not you can justify a percentage of time in the office. I think that's got to be backed. I don't think you can just potentially pluck a figure out of the air. That would have to be justified based on why you are saying we need more people into the office at more frequently than they are at the moment. Remembering, of course, that you probably need to make adjustments for part-time employees. If you're requiring all your full-time employees to be in 3 days a week, general view is that it might be difficult. If you've got an employee who does 3 days a week, it may be difficult to justify them being in 3 days a week, and that time in the office would need to be adjusted. So the percentage of time, I think, needs to be backed by the reason, and each company's reason for people being in the office will vary as ever. The flag is please be very careful about individuals who might have protected characteristics that could bring usually indirect discrimination claims as a result of your policy. So you need to be able to pressure test that.
I'll just flag there that we've got specific grounds, don't we, for refusing a flexible working request that you will need to align your rationale with, and it's always, as we will always encourage, having an open mind from the outset, doing your consultation within the business to understand why you need people in for that specific percentage of time. And we kind of refer to the reasonable test only coming in in the future. But if you want individuals to accept this proposal, they need to understand what the rationale is, what you're trying to achieve, but also you will need to align it with one of those grounds for refusal. So yeah, do that homework.
I'm going to just, Catherine, if it's okay, I'm going to do a quick, almost like speed dating. I'm going to try and go through those questions we haven't got to yet. So will the probation period have to align with the initial period of employment? No, but I think many employers may well get to that point, but let's wait and see what the period is.
And also, if your probationary period is longer than the initial period, then, so say you've got a 12-month probationary period, those last 3 months, you're going to have to go through a full dismissal process, because you won't get the benefit of that lighter touch process. And obviously they have unfair dismissal rights.
Yeah. Next question, do employees need to inform employer of a disability at the start of their employment? No, there is no positive obligation to disclose. Absolutely not. Hopefully I think most of the time employees are now being far more open about conditions, and you need to be, a lot of the training session I did last week was about identifying hidden disabilities, and those who are neurodiverse, you need to, it's almost a training of managers point to make sure that they are aware, how to identify it. Finally, what steps would you recommend employers take to prepare strategically, given much of the detail and final guidance is subject to consultation and failed releases? Crikey, that's a difficult question.
Yeah.
I think
Do you want me to
go for it.
Yeah, I'll jump in. So what I think the main thing that we're telling clients to do at the moment is to audit your workforce, to work out where the biggest impact these changes are going to have for your particular business, so that they can become the priority areas for you. I think that's the best thing to do at the moment.
It's 12:15. That's a wrap, Catherine. Over to you.
Yeah, well done, guys. As always, excellent performance and right on the deadline. So thanks to everyone who joined us today. Thanks, Stuart, Sean, Antonia, and Sarah. I know you're still on the line, for sharing all of your expertise. Just to flag, there's that link in the chat. We are doing another webinar Thursday next week, which will be hosted by our internal Ciphr experts, looking at things you can try to do to get ahead of the ERB. There'll be a particular focus around some of the payroll aspects, so thinking about aligning SSP, what you might need to update in your system as well, because although some of the things are still up in the air, it's worth starting to think about how you're getting your systems all ready for that changeover. If you want any more information about any of our solutions or about Shoosmiths services, you can opt in using the exit form you'll see at the end of this broadcast. We also asked you for some feedback there, and I always appreciate you leaving your thoughts. Thanks again, everyone, for joining us today live. We really appreciate it. We hope you have a great rest of your day, and see you again soon. Take care. Goodbye.
Thank you.
Thanks all.